Good morning, Your Honor. Brittany Bonner on behalf of the petitioner, Vivian Dean.
Good morning, Ms. Bonner, and I know I saw Mr. Dean on here.
Your Honor, George Garcia, the court reporter.
Good morning, Mr. Garcia. Okay, so let's make this official. We are here on FMCE 210000780, Vivian Dean versus James Dean. If you could announce your name again for the record.
Brittany Bonner on behalf of the petitioner, Vivian Dean.
Okay.
James Dean. Good morning, Your Honor.
Good morning, Mr. Dean, and you are here pro se, and I see Ms. Vivian Dean on here as well. And for the record, we are appearing on Zoom. So today was for just the argument on the respondent's motion for reconsideration. So your motion, Mr. Dean, if you would like to start.
Thank you, Your Honor. I would like to begin by reminding this court of its judicial oath to uphold and support the Constitution of the United States of America as per Florida Statute 105.031, subsection 4B, and also remind this court of its judicial oath to support the Constitution of the United States and the state of Florida as per Florida Statute 876.05, subsection 1. Furthermore, in making its ruling on respondent's recent motion to disqualify, this court has declared that it can and will be fair and unbiased, moving forward. I will accept that statement in good faith. So today, we're here to hear my motion for reconsideration, and there are several standalone factors that make it very easy for this court to grant my motion. Two of those things that stand out are poor administration of justice by the prior judge, who was recused for his behavior at that very hearing that the stay away order was implemented. Likewise, I asked at that time for a continuance for the 911 audio, which is now entered into evidence and available to hear today. Without the 911 call, there was no audio. The only evidence that the court heard that day was an illegally wiretapped video from the petitioner. Florida Rules of Judicial Administration 2.330, subsection H, provide that prior factual and legal rulings by a disqualified judge may be reconsidered and vacated or amended by a successor judge based upon a motion for reconsideration, which must be filed within 30 days of the order of disqualification. I did do so. Rule 2.330 requires the litigant to detail the reasons for the necessity of reconsideration and point the successor judge to all parts of the record necessary to determine whether to vacate the prior rulings. See Rath versus Network Marketing, and I will guide you today through the record and the mistakes that were made by the prior court. The purpose of reconsideration is to remove the taint of prejudice where rulings might be perceived as tainted. I did make a record last week that during the hearing where the stay away order was implemented, I actually had to defend myself on the hallway, on the floor of the hallway outside of your very courtroom. That is clearly not a fair trial. Florida Rules of Judicial Administration provide that upon receipt of a motion to disqualify, the judge shall enter an order granting to disqualify, but the judge did not do so. He waited 5 months and made 3 other rulings. I will show the court today emails between myself and the JA in which the judge subsequently disqualified himself 2 hours after my email. So the reasons for reconsideration are the grounds for the disqualification of the judge arose during the hearing on the said motion that we are hearing today. The ruling was based upon clear bias and denial of respondents' right to a fair trial. C, the wife's recent history of false domestic violence allegations. And D, the absence of the 911 audio recording from the husband during the hearing, which is the only actual audio evidence of the incident. If it please the court, may I share my screen?
Yes, 1 second, let me give you permission.
Your Honor, I thought this was just a non-evidentiary hearing.
Your Honor,
It was legal argument for a motion for reconsideration. If he, so Mr. Dean, if you're trying to introduce new evidence for me to rule differently, then that's not the evidentiary hearing. So today was you telling me why I should reconsider and vacate that prior order.
that is what I'm doing.
So now for you to convince me of a new order. Okay?
Yeah, we're here
So
today
it's
to
not
reconsider and to
introducing-
vacate that order based upon poor administration of justice, based upon fraud upon the court, and those are 2 of the 4 reasons that you can reconsider any motion. I would also,
Right, so
I would
then
like to read to you.
You're not introducing evidence today for me to make a new ruling. The whole purpose of today was legal argument why you think I should vacate that order, why I should reconsider it, vacate the order, and then give you a new hearing on that motion. Okay? So I don't know, you wouldn't need to introduce your 911 recording or anything like that today. Again, today's just the argument of why I should vacate that prior order.
And that's exactly why, because there's new evidence that wasn't at the original hearing. But anyhow, in North Shore Hospital, Inc. versus Baker, in the Florida Supreme Court, 1962, the Supreme Court reaffirmed the long-standing tenet that a trial court has the inherent authority to control its own interlocutory orders prior to final judgment. That means you may consider all motions at any time prior to final judgment. Further, in 1984, the 4th District attempted to clarify this apparent contradiction in Commercial Garden Mall versus Success Academy Incorporated, also in the Florida 4th District Court of Appeal, 1984. The court held that while non-final orders were not subject to a motion for rehearing, a trial judge nevertheless has the discretion to choose to entertain such a motion precisely because it has jurisdiction to control its non-final orders prior to entry of judgment. Therefore, you may look and even rehear any motion at any time. You have the standing to do so.
Okay, so the hearing that you had was on May 27th of
Yes,
2022?
Your Honor. Yes.
Okay, so let me ask Mr. Dean. I was asking Mr. Dean.
Oh, sorry.
Mr. Dean, the hearing was on May 27th of 2022, right?
Yes, ma'am.
And that one was the one that had to do with the no contact on the minor children and the exclusive use and possession of the marital home.
It was only
right?
on exclusive use of the marital home. The judge, even in the order, added that himself. He even mentioned it in the order that was not brought up by the opposition, that he decided himself to add the stay away order on his own recognizance. That was not sought. In fact, it was not sought because they already lost 2 prior domestic violence hearings, which is why they didn't seek the stay away order during that date. That was just given to them because the judge already had me on the floor in the hallway. You shouldn't have. Indeed, you should not have heard anything beyond that. I mentioned this to you last week. Sua sponte, once you heard that I defended myself on the hallway floor outside of your courtroom, you should have already vacated this. This is already wasting precious resources of the court system to have us here today. There's 2 small children, 3-year-old and a 4-year-old, that haven't seen a father in 17 months. It's going to be 18 months.
Mr. Dean, the notice of hearing for the May 27th, 2022 hearing, that was at 1:30, that was set in front of Judge Dale Cohen, that was back on Division 37, was on White's verified urgent motion for exclusive use and possession of home. The notice of the hearing says that it was to be held or heard by Zoom, before in courtroom 11154 of the
isn't that
Broward County Courthouse.
isn't that inconvenient?
So, Mr. Dean, I'm trying to go through it and ask questions. So if you would allow me, just like I just allowed you to talk without interrupting you, that would be great. So now, on that day, you're telling the court that you showed up to the courthouse?
Yes, I have irrefutable
Okay.
proof. It's even in the
And
it's
when
even in
you
the
showed up to the courthouse to appear into the courtroom at 1:30, you're telling me what? That the judge's deputy did not allow you to come into the courtroom?
that is correct.
And that what? Then you sat outside on the benches and
That is incorrect.
Had the hearing on your Zoom?
That is incorrect.
What is?
If I may
what's the
explain.
correct part?
Thank you. So I arrived approximately 1 p.m. for the 1:30 hearing, and I told them I'm here to appear for the 1:30 hearing. The sheriff said to me, "There's nobody doing in-person hearings." So I broke out my notice and I said, right here, it's noticed Zoom or room 11156. I'm pretty sure any prudent person, given the opportunity, the choice to appear in person or on Zoom, would arrive in person. So I did so. About 15 minutes passed, and we found the judicial assistant out in the hallway, and I showed her the notice. Look, I was noticed to appear in person here, so I'm here. Please let me in the courtroom. She went and talked to the judge, came back. She said the judge is not letting anybody in the courtroom. So then I sent her back again. Can you please tell the judge if he's not going to let me in the courtroom, which he noticed me to do, can he at least give me a 20 minutes continuance so I can go back to my office and defend myself in private? She disappeared. She came back. Now it's about 1:35, 1:30 something. And she said, the judge wanted me to tell you that he's already started the hearing without you now, and he's gonna give a default judgment against you if you do not appear in the next 5 minutes on Zoom. You may look at the record of that hearing, and you'll see before I arrived, he did say that to the court. Oh, Mr. Dean arrived in person. I'm going to square this away. I'm going to give him 5 minutes. What could I do if I'm knocking on the courtroom door, if I'm right outside of your door, and you give me 5 minutes? Where could I possibly go? Where could I possibly defend myself? How is that fair? In the duress that put me under, the immense duress, and you already know I'm a 100% service disabled veteran, to have me not on the bench, on the floor, with my stuff spread all over the floor that I can't find anything. And I had three physical copies of evidence to present. And now he says it's a Zoom hearing. So guess what? I went from all my evidence and exhibits in person to I can now have no exhibits because it's no longer in person. So my 3 physical copies are dead. So now I have no evidence. I'm on the floor. I'm panicking because people are walking by me. I'm under incredible duress. And there's no possible way that you can say that that's a fair trial, that's a fair hearing. It's clearly not. So everything that happened after that is with me acting under incredible duress, in which, of course, my mind wasn't as sharp as it usually is. Of course, I made errors. Of course, I let her say things. They got away with murder in that case because my objection list wasn't next to me. So when I'm objecting, I didn't have the proper words to use for my objections, to identify my objections, so he was overruling me. Everything was completely unfair. So the only objections I could have that I could remember were hearsay and improper impeachment, mischaracterization, and with those objections, my objections were being sustained time and again throughout the hearing. At the end of the hearing, the judge then used all the testimony during my sustained objections to rule against me. He sustained the objections, but then used the information to rule against me. They did not use there's not been any expert witnesses for PTSD. You look at the judge's order from May 27th. He said what concerned him is that Miss Dean said that my PTSD is really bad. Therefore, that makes me dangerous. And the court agreed. Yeah, PTSD makes you dangerous. The court has no knowledge of PTSD to make such an assertion. The truth is,
I don't see that in the order from May 27th, but anything further from you, Mr. Dean?
Absolutely. I wanted to share my screen with you.
So there's no need to share the screen. Again, a motion for reconsideration is you're telling me or asking me why I should vacate that order from May 27th of 2022,
And I'm-
because you're claiming that the hearing was not fair. So
That was only
there's
one
no
of-
need for you. You're not proving or anything on the actual motion that was heard on that day.
That
The
was-
hearing today is only telling me why I should vacate that order. Ms.
That-
Bonner, response?
I'm
First
not,
of all, I want to state that Mr. Dean, just as in your last hearing, was informed that the hearing would be via Zoom. So he was on notice that it was going to
objection, Your Honor, Your Honor, you were there, and me and you had,
You're not going to interrupt her. You're not going to interrupt her. I didn't allow her to interrupt you.
she did interrupt
You're gonna,
me.
if you have an objection, you can make a legal objection, and that's it. Go ahead, responder.
Yeah, so Your Honor, I'm not sure if you reviewed the transcript from 527, but the transcript of that hearing speaks for itself. No testimony was taken. I had to restart the testimony when Mr. Dean arrived. I'd only gotten into a few questions. We restarted it when he appeared.
Objection, I just testified that I appeared way
This
before
argument,
that.
and I don't see
Miss-
how anything's objectionable. I
Okay,
should-
we're not gonna argue against, we're not gonna argue with each other. Mr. Dean, you made your legal objection, overruled. Go ahead, Ms. Bonner.
Okay. So, Your Honor, we presented video testimony and I presented the evidence of my client regarding the issue of exclusive use. The judge says in the transcript that he was so disturbed by the video and the testimony
Objection,
that that's
objection,
why he
relevance.
entered this order.
Overruled.
This has
Your
not,
Honor, we were both given equal time in this hearing because it had to start over, so it started 10 minutes late. We were both given about 20 minutes because he had somewhere he had to be. So we were given equal time. He kept telling Mr. Dean that he was going to give him a lot of leeway because he was pro se. And as Mr. Dean said, he did make objections, and the judge actually sustained most of his objections. So there's no reason why he should be arguing that this is an unfair hearing. He didn't try to introduce any evidence. He didn't bring up to the judge, it's not in the transcript, that he had any evidence. He mentioned a 911 tape, but there was no 911 tape at the time. And Your Honor, then he issued this order after hearing the testimony, and it gave Mr. Dean options to regain time sharing with his children. And yet, a year and a half later, Mr. Dean hasn't done anything to regain the time sharing with his hearing or to rectify the situation. Now, after this order came out, Mr. Dean filed a motion to disqualify based on what the issues he raised now. The judge denied that motion to disqualify at 6:27. It wasn't until October 17th that the judge sua sponte disqualified himself, but it wasn't based on his motion or anything having to do with this hearing. So Mr. Dean citing Rule 2.330, that does not apply. Now, again, as a review of the evidence in the transcript shows that there has been no mistake of law, there has been no taint of prejudice in this case. The judge reviewed the evidence, heard the testimony, both sides had equal time to present their case, and the evidence was overwhelming. And just to let you know, the case law is very clear on exclusive use and possession. And if you look at Bowles v. Bowles, 384 Southern 2nd 299, so the trial court affirmed awarding exclusive use and possession to the wife where there was evidence just that the parties were quarreling. Burnett v. Burnett, 28 Southern 2nd 878, the court may require parties to divorce live separately if public decency, safety of the parties, or welfare of the children requires. The video shows Mr. Dean holding a child who is screaming, a child who is bruised. There's an altercation. Mr. Dean attacks Miss Dean's father, who's holding the camera, and gets in his face, and the camera goes dark. Your Honor, these are just one of many incidents that there was testimony presented about Mr. Dean causing problems in front of the children in the marital home and being in danger. He admitted that he had PTSD. He admitted it wasn't being treated and that it was getting worse. So the judge had heard all of that testimony, and there's no reason why this order should be reconsidered or vacated under the law. And to do so would put not only my client, but these two very small children in harm's way because Mr. Dean still has not received anger management or therapy or any treatment whatsoever for his PTSD, Your Honor. And you've seen him in court prior, and
Objection, Your Honor. This is objection. This is scandalous. This is scandalous testimony. Objection.
Okay, what is your legal objection, Mr. Dean?
Mischaracterization of even the experience that you were there for. Now she's trying to mischaracterize it to you.
Okay, overruled. Continue, Ms. Bonner, with your argument.
So even in December when we started hearing on this motion for reconsideration, Mr. Dean's conduct resulted in basically an order for criminal contempt. We couldn't finish the hearing.
How his conduct was. We're only here on his motion for reconsideration. We're not on here for anything else.
Well, Your Honor, no, Your Honor, there's no mistake of law, there's no taint of prejudice. The transcript speaks for itself, and these children would be put in danger if this order was vacated, Your Honor.
Okay. Anything final, Mr. Dean?
More than final. You cut me off last time, and you said you were stating that. Oh, the only thing you're saying, if I may make a record, you're cutting him off now again.
If you want to make,
I'm trying to make a record. I'm trying to, but you're not allowing me to. If I may speak.
Go for it.
I am attempting to. If you'd please let me make a complete record without interruption, I would appreciate.
I just said go for it 3
But
times.
I'm trying to.
Stop arguing with me. Just make
I'm not arguing. I'm trying to speak, and you're not letting me. So, I was telling you before that it was not just reconsideration because it was not a fair trial, which was a fact. It was not a fair trial. And if I may also share my screen with you,
No, you're not sharing your screen, sir. Again, the motion is for reconsideration. You're asking me to vacate
but you're not.
that
You're
order
not. I
and
still
have
can't
a
make
new
a complete
hearing on
record.
it. So if we have a new hearing on it, then at that point, you can introduce any evidence that you like. The motion for reconsideration is you're asking me to vacate an order that was entered back on May
Correct.
27th of 2022 for a hearing that was held in front of Judge Cohen.
But you're
If
not.
you want to make arguments as to why I should vacate that order, I am all ears.
Well, I appreciate it. That would mean that I would need to be able to speak so you can hear me. So I'm also telling you that the secondary factor, which is another standalone factor, is fraud upon the court. You may reconsider a motion for fraud upon the court. I know you don't want to hear it, but I'm gonna get it. I'm gonna get that record out. This is fraud, and I'm trying to share my screen with you so I can clearly show you in 2 seconds that she's defrauding you. Brittany Bonner's defrauding you even as she speaks now. I can show you an email that would decisively show you it is untrue what she's saying. Hey, objection, Your Honor. I'm trying to make a complete record, and she's again. How come she's allowed to interrupt me, and you say Miss Bonner, but when I interrupt, you make threats to me?
Just like you did. What is your legal objection, Ms. Bonner?
This is badgering. This is an
That's not a legal objection, Your Honor. Please.
Overruled.
Just representing
Overruled.
the judge.
Overruled. Continue, Mr. Dean.
I can show you fraud upon the court with her statements she's just made to you that, oh, it was a fair trial and he was recused from something else. If I may share my screen with you, I can show you the email that he would recuse himself from that hearing.
There's an order that he recused himself on October 17th of 22.
Yes.
There's nothing that you need to show me. The order of recusal is on CMS. I have seen the order of recusal.
What she's
So
saying,
what else would you like to argue?
what she's saying is that he recused himself for some unknown reason, but it was not prejudicial treatment towards me. But if I can show you an email sent 2 hours before his recusal, 2 hours before his recusal, you'll see that he was saying, I want to see you guys in person. And I said, are you going to see me again in person so you can put me on the floor outside of your courthouse? Is that what you're going to do? And then he recused himself within an hour. That is not a fair trial. That is absolutely pertinent for you to make your ruling on this hearing. If you're not to see it, is again denying me my opportunity for a fair trial. Motion for reconsideration can be heard based upon fraud, but you're not even willing to look at the evidence of fraud that I have prepared to show you and I entered into the record. In fact, you granted the motion in Lamine last week because you said that I didn't have evidence on record in time. Now you're telling me that you're not going to see now that I have it on record, you're telling me, hey, I'm still not going to hear your evidence. So then why didn't we do this 8 days ago if you weren't going to hear my evidence anyways? You're tricking me. My kids haven't had a father for 18 months. You are.
I'm not tricking.
You are. And you also last time told me we're at the end. At the end of the hearing, you also told me this was going to be an in-person hearing. We both spoke about that. I'm sure you remember. You did. You asked me. You said, Mr. Dean, are you going to obey my deputies? And I said, I obey all lawful orders. You said, next time you come, if you don't tell me that you're going to obey if you don't obey me, my deputies, I'm going to cancel your hearing, Mr. Dean. If you don't say yes. And I said, okay, yes.
Mr. Dean, I just muted you because you keep interrupting me.
I did not interrupt.
We have to make a record where one of us speaks at one time. The court reporter cannot take down two people talking at the same time. Okay? So I know what I said, and I made it very clear that this motion was going to be on Zoom because it was only legal arguments and only arguments with no testimony, no evidence. You have a few other motions that you have pending. You have a motion for temporary support. I told you that one would be in person because that one you are introducing evidence. And for that case is the one that I told you that you need to pay attention and actually abide by the rules of the Broward Sheriff's Office, who are in charge of security for the whole Broward County Courthouse. And since there is a no contact order on this case, you have to abide by where they tell you you can stand or cannot stand while you're outside of my courtroom pending a hearing. So that's what I told you. I know, and I'm very clear on what I said in court. You can disagree with me all day long. If you would like to say any other legal arguments on your motion for reconsideration, then you may unmute yourself and make your final arguments on the motion for reconsideration.
My motion for reconsideration is based upon fraud on this court, which this court would not allow me to show, and also based upon a clear, unadulterated, prejudicial, unfair trial. There's never been a more unfair trial in the 17th district than there was that day. I can guarantee you that no lawyer in the history of our country has ever had to defend anybody on the not a bench, as you tried to allude to. No. The floor of a hallway outside of the courtroom door with people walking by, and for Miss Bonner to say, that's fair, that's absurd. That is misrepresenting her knowledge as a litigator. This court knows very well that that's not a fair trial. You, in fact, yourself told me last week, Your Honor, that if that was the case in your courtroom, that you would have not had me outside the court. You said you would have brought me inside the room, and you showed me the little TV that I would have been sat in front of. That is not what happened there. So clearly you do not see that as a fair trial. Please uphold your own word and grant my motion to vacate this motion for reconsideration. Thank you.
Thank you. Okay. I read the transcript. The transcript shows that the hearing had started without Mr. Dean being on Zoom, but then when he did get on Zoom and the court asked him if he could hear, and that was actually clear that Mr. Dean could hear and that the court could hear Mr. Dean, the hearing was started again. At that point, it was started with Ms. Dean stating her name, her information, and then the hearing went on with objections being made by Mr. Dean, the judge sustaining some, overruling some, but there was a full hearing on that matter. And based on that hearing and what testimony came in and what evidence came in, Judge Cohen made a ruling. I do not find that I have sufficient grounds to vacate that order, so I am denying your motion for vacating that order. Okay?
No, that's not okay. I'm gonna move this court to disqualify the judge at this time. Your prejudicial treatment is noted.
Sir.
Well, I've made the verbal.
You're not muted. You can put it in writing as the law requires.
No, it does not require. It does not require that.
I don't think we have any of the other stuff.
The motion, I can make that motion in person, and as I've done, it's an oral motion.
Sir, I'm not allowing you to unmute yourself again. You have to put it in writing. You can file it, and I will rule on it. Okay? Thank you, folks. The hearing is over.